All right, welcome back, everybody. Today, I'm super excited to have Amy Xiao with us today. Amy is a trademark attorney that helps U.S. companies protect their brands, their designs, and their trademarks when they manufacture and sell in China. And Amy's worked with a number of multinational corporations, and she has over 100 wins protecting these brands and their trademarks when they work in China. So I've invited Amy to join us today to this masterclass to share some of her best practices that you can take away and you can use as online sellers and small businesses when you're sourcing products from China. And then Amy has a great presentation that she's going to run through with us. And then afterwards, we'll have some questions and answers. So without further ado, please welcome Amy.
All right, thank you, Gary. So I'm going to go forward with my presentation. I have about 30 slides, and I just want to talk about some key differences between the trademark practice in the US and in China, and what are the possible nightmares for you if you're just if you focus on manufacturing in China. So should I go ahead and share that right now?
Yes, that's perfect.
Okay. Share a screen and stop myself as video. All right,
Perfect.
all good, right? Okay,
All
perfect.
good.
Okay, I am going to, all right, the next slide. Well, before we talk about details, I just want to share with you a little bit about my background. And like Gary mentioned, I'm native Chinese. I grew up in Taiwan, and I came over here about 15 years ago, go to law school. And I practiced with some of the largest law firm here and doing protecting brands specialized in China. And the rest is kind of like history, so I don't want to bore you with details. But there is one thing I want to share with you. Like, if I just manufacture in China, a lot of my clients will say, if I just source from China, I just manufacture it from China, why do I need to care about my IP rights? Well, without telling you a lot of the horror story, I want to share with you something that some clients I just came over. This client was, right now is a pretty big brand right now in the US, but about 15 years ago, when they first started to invent the products, they're very tiny, very small. And what happened is that they told me they went on Indiegogo. A lot of you probably familiar with that. So they got to Indiegogo. They collected a lot of money. They even told me they are one of the one that collected a lot of funds, like fastest way or something like that. So everybody was really happy. They collected a lot of money, and they're gonna start sourcing from China. So after doing data, all that kind of stuff, they finally selected a Chinese manufacturer. Looks really good and everything from the top. So that's just called as Chinese manufacturer, Mr. Wang. So they placed an order that say January 1st, 2000. They placed an order on there, and the went ahead and manufactured everything. So what happened 7 days later, January 7th, Mr. Wang actually filed for my client's trademark back at that time. And the client discovered this, but they are not really concerned, and also they don't really know the Chinese trademark law. So they're like, you know what, that's in China. I don't really care. I'm gonna just focus in the US. January 10th, Mr. Wang went ahead and filed for the client's design patent. So that was 2000, that was about 18 years ago. And since then, fast forward to now, 18 years later, right now, the client is really big and like really successful Amazon sellers. So they started to go into China. But what they discover is, first, all their trademarks are taken. Second, all their design patents are taken. What that means is that the client will not be able to sell or retail or even advertise in China. So in addition to giving up the Chinese market, what happened is that this guy, Mr. Wang, actually sell everything to the client's competitor. So one day the police came up and showed them the trademark registration certificate of our client's brand, and actually shut down the manufacturing and affect the whole worldwide shipment. So that's what's really going on in China. If you don't have, like, I don't want to talk about a lot of things like very, very expensive protection. If you're manufacturing in China, you're selling directly and sourcing from China, what I want to tell you is what is the most important part just to protect your core. So without further ado, there are 3 questions that I get a lot when it comes to China. And we in the whole presentation, we're just going to focus on if you're just sourcing from China, you're not doing retailing or marketing in China. So the first question is, does a contract really protect you? My answer is, as a lawyer, of course a contract protects you. I'm not going to say the contract doesn't protect you. But the practical question here is, if there's a problem, and there will always be a problem, are you really going to invest $15,000 to $20,000 to litigate in China in a language that you don't even know? So without a contract, without litigation, what is the thing that can really make sure you're protected? That's what we're going to talk about here. The second one is, what are the key differences between the West and China? I'm not going to talk about 100. I'm just going to focus on top 3 key differences. And the last question is, what are the landmines? And that will be on slide 25, probably the end of here. Okay, so before I do any presentation, I always want to start sharing with you some statistics. Especially in China, it's a little bit difficult to get the real statistics. But in here, in the chart, you can see what's going on in China. We're not talking about some third world countries. China has been number 1 in terms of trademark filings in the whole, in the whole world, not just for 3 years, not for 5 years, but for 15 consecutive years. Next one. So what happened? What about the numbers last year in China? In 2017, there are over 5 million applications that were filed in China. And you'll be like, okay, Amy, that sounds really great, but what about the number in the US? The number in the US in the same period of time, it's about 500,000. So in other words, the number of filings in China right now, it's more than 10 times the number of filing in the USA. So China is today one of the actually the biggest IP in terms of trademark, in terms of patent right now. So with that in mind, we're going to talk about these things. We're not going to focus on contract. We're not going to focus on purchase order. We're going to focus on IP only in the next 20 minutes. We're going to talk about 3 key differences and what are the impact to business. And I want to share one story at the end of the slides. So without further ado, let's go forward. Okay, what is the key difference? The biggest difference between the US and the trademark law, and the question for you is, are you really protected under the Chinese law? So what does that mean? The next slide you will see, there's a picture of shoes and there's a picture for socks. So under the US system, if you have a trademark, let's just say Nike, you have a trademark for Nike and you are covered for shoes. And under the US system, you don't need to specifically say Nike and you need to cover for socks because shoes and socks, they're related. Under the US system, you just need to say one thing, and because they're related, you are automatically covered, you're automatically protected in that way. That is the US system. That happens in US, that happens in European Union. But when you cross over, to Asia, when you come over to China, what's going on right now is China has the subclass system. What that means is that everything under the world is being categorized into 45 international classes. And just bear with me, this is a little bit technical. But in a trademark system, in the Western world, everything is divided into 45 international classes. That is also true in China. But what happens in China is that they further divide them into millions, tons and tons of little subclasses. So coming back to our examples, we have shoes and socks. In the Western world, I'm gonna let it sink in a little bit. In the Western world, you register for shoes, you are protected for socks. But in China, because they're further divided to multiple little subclasses, if you just focus on shoes, you are not protected for socks. In other words, if I'm your partner in China, or if just like the beginning story, I'm Mr. Wang, I can go ahead and register your same mark in the same international class before SOX. And there's very little thing, very expensive for you. There's very little legal action you can do to go after me. Next slide, I want to show you, this is a little bit technical, but I want to show you what it looks like when you register your marks in China. And just by the way, if you have any questions, just feel free to ask me along the way. I kind of like the conversational style. But coming back to the slide, first of all, you're going to see a lot of smiley faces. This is because these are real life examples, and I black out the client sensitive information just to show you. So what's going on the slide is that when you register your trademark in China, this is what it's going to look like. And a lot of you don't read Chinese, but what's really key here is on the right-hand side, the part that's circled in red. That means your mark is here. There are a lot of description, but they only correspond to one subclass in China. And you'll be like, okay, Amy, what's wrong with that? What is the real impact to my business? Well, here's how I show you the real business impact. This is the chart of a pretty major Western company. This is their portfolio when they register in China. So you can see that their key classes in China are class 1, class 9, class 40, class 42. Class 9, let's just pick one class. Class 9 will be a lot of your key classes here. They are like speakers, computer accessories. So in the Western way, I don't know if you can see my cursor, but in the Western way, this guy in the Western filing is only covered in 2 classes. This company is only covered for computers and some scientific instruments, only 2. But under the Chinese system, there are 24 subclasses right here in class 9. In other words, this guy, there are 22 holes in this registration alone. What that means is that if I'm your distributor, I'm your partner in China, or even I'm just your former employee and I'm not really happy with you, I can go in, register your mark in your key class, and there are 22 ways I can pretty much mess up with your registration in China. So with that in mind, and you'll be like, okay, so Amy, what is the ideal registration that should look like? So this is what the really should look like. Again, I black out the client sensitive information. Right here, you see a lot of descriptions. They are in Chinese, but what's really key here is that there are a lot of numbers that shows they correspond to each numbers, a lot of the subclasses in China. Same thing in here, a lot of descriptions in Chinese, but also a lot of numbers. That means they are fully covered in a Chinese way. All right, so here's the myth, here's the question now. A lot of people, and sometimes when I go with the delegation, sometimes meet the Chinese authority with the US or European authority, there are a lot of complaints. There are a lot of issues, and people are always complaining about, I already have registration in China. Like my brand is ABC. My brand is already registered in China. Like, let's just say I sell t-shirts. I already registered ABC for t-shirts in class 25. Why would an infringer's mark still can register ABC in class 25 for gloves? This is why. Because in class 25, there are multiple subclasses. If you just go in and register your mark in t-shirt subclass, an infringer can come in and register related products, gloves. Same thing, I have a lot of fitness clients. So what happened is that they will just extend to China in the Western way, and they will just cover one out of multiple subclasses in class 28. So the infringer can still come in and say, I'm going to use your mark, but I'm just going to register related class. So what happened is that sometimes you spend a lot of money, invest a lot of money, do marketing, but the infringers can still piggyback and register your same brand. So there's really easy way to defend this. All you need to do is understand Chinese system is subclass system. We need to fill out the holes. So that's the first part. Second part will be, what is the second big difference between the Western system and the Chinese system. For me, that's a common law rights. And let me explain a little bit more. A lot of the stuff, especially starting from this section, is going to sound really crazy to you because we grew up in a Western system. We understand the Western culture. But I just want to make sure, starting from the front, that a lot of the story I'm going to share with you, I do get them from the authority. I'm part of the textbook right here. That's pretty much the first textbook for China's trademark system. So without further ado, the key issue here, I don't want to go through a lot of rules, a lot of law, but a basic takeaway, the most basic rule, if you're just manufacturing, if you're just sourcing from China, the most important rule for you is that use does not give up to any rights in China. It does not give rights to any rights at all in China. What that means is China rarely recognizes common law rights. So let me explain a little bit more. In the US, let's just say the barbecue shop that I go to a lot, the barbecue store, they don't really need to register their rights. They have been cooking the barbecue, the pork ribs for 20 years. They don't need to register their trademark. But in the neighborhood, in the city, in Atlanta, in Georgia, they become well known. They do have rights. Because in the US, in the Western world, when you start using that, you do have rights. You don't need to necessarily register that. However, in China, in fact, most of the Asia, especially like Indonesia or Philippines, if you manufacture there too, even if you've been using that for a long time, and even if the local people all know you've been using that for a long time, you still do not have rights unless you register that under their system. So that is the biggest difference. So let me share with you some of the examples what this will show. These are actually, all of them all happen in China. So for example, let's just keep some examples like BMW. BMW is really famous for cars. Cars are class 12. So BMW is really famous for cars in class 12 in China. But an infringer can still come in and register BMW for clothing line, for t-shirts. This is because even though BMW is really famous in car industry, it doesn't have common law rights. So somebody can still come in and register that, and it's a huge fight for BMW to get rid of that. The other one is Lipton. Lipton is really famous for tea in class 30, but a Chinese infringer can still come in, register the same mark in class 11 for refrigerators. This is because, again, there's no common law rights. So let me share with you just two examples in 2016. It's the same thing that happens here. Facebook, an infringer come along. Facebook is online search engine, online like social media in class 45. And this infringer came along, registered Facebook, but this time for canned vegetables. Same thing for Apple's iPhone brand. iPhone is famous for cell phones. Cell phone is class 9. But its infringer come along, register iPhone before leather products. That's an entirely different class 18. And both brands, iPhone and Facebook, they have to fight 4 different levels all the way to the Beijing court. And it's just not a smart move, especially for small businesses. We don't have that kind of budget, especially legal budget, to go all the way to the Beijing court. The next example I want to show is for President Donald Trump. So either side, doesn't matter which political side you are on, President Donald Trump is pretty famous. He's not famous not just in the US, he's also pretty famous in China. And I also wrote an article about Donald Trump and also his daughter Ivanka Trump. They do have trademark registration in China. For example, Donald Trump registered both Donald Trump in English and in Chinese characters in class 36 for real estate services. However, even though he's famous, even though in the Western system he will be able to enjoy common law rights and stop other people from using his name, but in China, even though he's famous or whatever, a third party you can see on the right-hand side can still use his name in both English and Chinese characters for different class. In this one, for toilets. So entirely different, but they can still do that under the Chinese system. So here, there's one practice point for you. Because of the way that China doesn't recognize common law rights, I want to draw this to your attention. How does that impact your business? Well, when you're first starting out in China, you sign the agreement, you love your manufacturers and you love your distributors, for example. The first 2 to 4 years, maybe the relationship is really great. But when you start to get bigger, one of the compliments is that you are going to start seeing like infringers and counterfeiters and people take away your IP rights. So your business people on the ground will start getting really upset and see people having your IP rights and call all the way back to the US to the headquarters to say, this is really ridiculous. We're going to send out a cease and desist letter. And you're going to call your attorney and go out, send out the letter. Well, don't do that. The reason is because in the US, you can do that. Like somebody traveled to Georgia, somebody traveled to like somewhere in the US and see some other people use your IP rights. Yes, you have every right to get upset about this. You can send out a cease and desist letter. It's because you already have the brand. You already use that. You already have rights under the US system. However, in China, and also this really applies to the rest of Asia as well, but in China, even though this is your brand and you've been using it for a while, remember what we talked about before, you don't have common law rights in China. That is why in China, when you send out a C&D letter, a demand letter, be very, very, very careful. You want to make sure that not only you do have rights in China, but also your rights trump the infringer's rights. And let me explain that a little bit more. What it means is that you do have rights, you have registration rights under the most important subclasses. And the right you're basing on is not just the common law rights, because the table can be, they can turn a table and they can turn around and sue you, make you become an infringer to your own brand under the Chinese system. That's the case we're going to talk about on the third difference. I also want to mention here, this is a trend that we start seeing in China. On the right-hand side, you will see the Tiffany and also the Audi case. What I mean here is that a lot of the time we're dealing with infringers, especially after 2014. The infringer's business is a very lucrative, very powerful business. So like I want to share, I'm not going to go to details, but in Tiffany case, in Audi case, which is 2 years ago and 1 year ago, in both cases, in the Western standard, the infringement is pretty egregious. They copy just the exact Audi mark and exact Tiffany mark. But Tiffany and Audi both win in the first case. But in both cases, their infringer turn around and sue them to the Beijing court. So the point to take away here is that when you send out a C&D letter, especially to infringers, by all means, make sure you do have the IP rights because they can turn the table around and make you the infringer under the Chinese system. Get some water there. This is a second practice point. I want to show this because I see this a lot in my line of practice. Because of the Chinese system, because of the Chinese culture, people and companies, even though they're pretty advanced right now, they are set up in a way they don't like to. There's a distrust to for lawyers. As a result, they don't like to. Like in the U.S., sometimes you send out a cease and desist letter, and you follow up with an email, and people can talk about it and reduce the problem, and just kind of get the problem go away without actually suing people or filing opposition action. That's in the U.S. People talk about it, people resolve it. But in China, because of the distrust and the way people are set up, companies are set up, it is already very, very low average rate that if you send out a C&D letter, very, very rarely people are going to respond to you. As a result, if you're trying to get higher rate of the response to your demand letter, the best way, by all means, send them out in Chinese letter, because just imagine you're already really, really busy and then somebody send you a demand letter in Chinese, and probably you're so busy, there's no time for you to translate that and figure out what they are talking about and respond. So if you do want to respond, especially for very key, if you're fighting for really key marks, by all means send out a C&D letter. And this is not very expensive at all. Like we send out a C&D letter in Chinese more than 100 a month. So this is not something that's going to break the bank. We do this a lot of the law firms do this on a routine basis. All right. So we kind of come to the end. The third difference I want to point out, and remember we talked about before, what is the most horrible story that could possibly happen to a person sourcing from China? Here's the question. Is it possible to be an infringer to your own brand in China? Before I answer that question, I want to share something first, because this is a myth that I hear a lot every day in my line of practice. Because sometimes you may start out small right now, you might be a small brand, but 10 years from now, just like the client we got, 10 years from now, you may be a really big brand. But when you come back, you want to do retail, you want to do marketing in China, you find out all your brands are taken, and you'll be like, really upset with your attorney. How can they forgot to register my Chinese name? But here's the problem. There's no set way to find out your Chinese name. For example, I want to show you the car example. On the left-hand side, the BMW. The BMW Chinese name is Treasure Horse. It doesn't sound like BMW. It is pronounced as Bauma. It doesn't sound like BMW. It does not mean BMW. It is a concept translation. Same thing with Mercedes-Benz. Mercedes-Benz's Chinese brand is Benzi. That means horses galloping or running really, really fast. It does not sound, it sounds a little bit, but it does not mean Mercedes-Benz. It's a concept. So what is the modern way to come up with your Chinese brand? It's not really just on the sound. It's not just on the translation, because a lot of times the English brand doesn't have translation. It's more based on the concept. What is the essence of the product? With that in mind, I want to leave with you just one last story, the New Balance story. So Gary heard me share about this before. This is because I do this kind of presentation a lot, and also a lot of the time to in-house attorneys, to attorneys practicing in the U.S. So you will see what are the top 3 cases of this year, what are the top 5 cases of this year. In the past few years, I always consistently choose the New Balance case, because this case is really, just because it's really shocking. It cannot happen in a Western standard, but it does happen in China. And you will probably like, Amy, this is probably a really old case. No, it was decided in December 2016. So let me share with you what happened. The New Balance case, when you have a brand in China, most of the time, 90% of the time, you register the English brand. But over time, the market will come up with a Chinese name for you, because it is difficult for us, the native speakers, to pronounce the English brand. So you see the chart below, because I have an article about this one. So we did a pretty deep analysis on New Balance. Over time, over the 20 years New Balance was in Chinese market, the Chinese market came up with at least 5 different versions for New Balance, 5 different entirely versions. By 2011, so New Balance, rather than registering the mark, there's one version that became very popular, exclusively associated with the New Balance English brand. So rather than registering this, grab this immediately, New Balance actually convert their business, start using these characters to advertise their products, their shoes. But they don't have registration rights. So what happened is the infringer, Mr. Zhou just came to the picture in 2011 or something. He registered these characters for shoes. By 2013, Mr. Zhou decided to sue New Balance because New Balance was using these characters for shoes. And this is what happened. Under the Chinese system, Mr. Zhou won the case. So New Balance was recognized as an infringer to its own Chinese characters, to its own Chinese brand. The first decision, New Balance was asked to pay almost $60 million. In the second decision, New Balance still need to pay about $1 million. But most importantly, in the court decision, New Balance was recognized as an infringer. It has bad faith. It need to issue a public statement to kind of just apologize. And this is, if you want to find out about this a little bit more, I do have a published article on this one. You feel free to Google that or just email me for a copy. So what is the New Balance decision? Why is that such an important one that will impact you? If you're just doing sourcing, manufacturing in China, why does it matter to you? This is because like the Tiffany, the Audi case, for example, we start to see the infringers in China turn more and more aggressive. So when your brand are taken in China, what happened is that the infringer will then report you to the local policeman, and the local policeman will show up in your factories, sometimes will stop all the packaging, will stop all the outbound shipments, and that as a result will influence the supply chain to the rest of the world. That to me is usually that to me definitely is the worst nightmare. And the bad thing for this, the timing is always bad because it always never fails. It always happens during the Christmas time when it is like your product's going on a huge sale in the US and then the supply chain got shut down. So coming back to the last slide, we talk about 3 key differences here. So what are the takeaway? For me, takeaway, there are 3 things. For IP protection in China for online sellers, first one, China is the first to file country. Not just China, but the rest of Asia, but China especially. They are very rigid about this one. So make sure you are covered in the most important mark, in the most important subclasses. The second one, the common law rights. If you just use the mark in China, there's no rights, absolutely no rights. You need to register that. The third one is make sure your infringer, your competitor, don't get your brand. And I do want to make a reminder here. A lot of the time when we file for copyright, trademark, design patent here in the US, it takes a long time and it's pretty costly. The good thing about China is that when you get in at the front end, like let's just say I want to file for a design patent because I have some unique feature to my product, for example, by all means file that because China doesn't have substantive examination. In other words, you will not get refusal all the time and spend a lot of like tens of $20,000 just to deal with the refusal. China just pretty much just goes straight through. So for me, if you are an online seller and you're a manufacturer sourcing from China, you're not doing any retailing, not doing any marketing. The basic thing for me for the IP is absolutely protect the core, protect the factory, protect the packaging, protect the supply chain. And last one takeaway is if you do want more about this type of information, focus on trademark, branding, and design patent in China, we do have a blog. And sign up for a blog is completely free for your free monthly newsletter. So that's it for the presentation. I'm going to get it back to Gary.
Thank you so much, Amy. This was an excellent presentation. We covered a lot of great points. And yeah, I think one of the top questions that you just answered is, you know, a lot of the people in our audience and our students, like if they are only manufacturing in China, they don't plan to sell in China, is it still necessary to register in China? And then I think what you shared is, if there's a Chinese infringer on your trademark, if they've registered your trademark, they can actually tell the police to stop your factory from manufacturing and shipping your product. Is that correct?
Yeah, that's correct. And that's really just the hassle you don't want to deal with. In other types of the world, for example, in Indonesia, Philippines and stuff, there is a way to get around that, but in China, it's a little bit more strict on that part. So a lot of the time, like people will say, oh, there's no way people are not gonna register my mark. People are not gonna steal my design. I can pretty much guarantee you for branding right now, in 3 months, somebody will steal your mark. For design patterns, sometimes they're a little bit faster. And you'll be like, oh, what's the impact to me on that one? What we are seeing right now is, especially after 2014, the average income in China goes a lot higher. So the infringer turns a lot more aggressive. So they can turn the table around. I don't know if that's the right American expression, but they can turn the table around and they can take the certificate and go to the local office. It's called AIC, and they would just say, "This is my brand," just like the New Balance. "This is my brand. I cover shoes. They are manufacturing shoes. Go shut them down." So there are ways to unravel this, but you don't want to go there because it's really expensive, and usually the US will be really upset and very, very difficult to deal with too.
Right. And then, as, some people say, especially in sports, offense wins games, but defense wins championships. So I think that's
Yes.
true, in terms
Yeah.
of protecting your IP, your trademark. If you don't do that, like, similar to what happened to New Balance in China, I've lived in China for over 10 years. And then I don't even know like the Chinese like New Balance brand. I think the reason is, what you just explained, because, the infringer actually registered their brand before they did. I mean, so
Yeah.
it just goes to show like the extent of, what's going on here in China, how you really should protect yourself. And
Yeah.
I think, one thing you mentioned was really interesting, Amy, is in terms of, filing for trademarks and patents. And you said that it doesn't, like in China, they don't have like a really substantive examination. It can just go straight through.
Yeah.
Like how long would that take to file for, and how much money should one budget for that if you were an online seller?
Um, it's a big question. It really depends. Like, I will have to say, like, before 2014, I keep saying 2014. The reason is because China went through a major overhaul for the trademark system. So we're under the new law right now. So before 2014, it can easily take like 5 years or 10 years, just like we're dealing with India right now. It takes like 10 years to get a mark register. But in China right now for trademark, it's about 9 to 12 months to get a mark register because the examiners are personally liable if they don't push it through. For design pattern, it's under a year. For copyright, I have seen it like file it today. In 2 months, I got a trademark registry, I got a copyright certificate in 2 months.
In 2 months.
So in terms of trademark, coming back to the first one, for trademark budget about $2,000 to $3,000. It's over budget a little bit, but it makes sense to do that. For copyright, it's about $1,500. For design pattern, it really depends. There's a wide range. It can be really cheap, like $1,000. Sometimes go up a little bit more, but that's the time frame. Okay. And it's really important because a lot of people will be like, okay, I don't care about my mark because I'm not going to sell in China. I guarantee you if you become really popular, because right now like JD is huge, Alibaba, Taobao is huge. The basic threshold is that if you cannot produce a trademark certificate, for example, you cannot do anything. You cannot even get listed on JD.
Right. Yeah. And for those of you who aren't familiar with JD, JD is Jingdong.com. It's kind of like online e-commerce platform in China, kind of like what do you call it? Like an Amazon of China. Is it's quite popular. So yeah, I mean, China has one of the largest e-commerce markets in the world now. So just thinking, in the future, that could be a good opportunity. Okay.
And also for licensing too, like later down the road, we're going to start licensing, and that also affects your ability to take money out of China too, because the banks will even want to see that.
Interesting. Okay. And a follow-up question, like pardon my ignorance, but what is the difference between a trademark and a copyright?
Trademark, the easiest way is trademark is your name. It's kind of like your brand name. What is your brand name? Like Apple is the brand name. It's a source identifier, how people distinguish your source. Copyright is more like, I would say kind of like design. We can, this is really complicated because they do overlap. You can have a 3D, like 3D trademark. You can have a 2D, 3D copyright, but usually we do copyright for design, with designs like logos and stuff. And like, for example, like animation. This is another aspect for Chinese that are more flexible. Under the US, it's really hard to get animation for copyright, but in Chinese, you can get copyright for 72 different artwork of a same little guy animation. So that's just a way, like a little thing, design or characters or spokesperson, put it under a copyright.
I see.
Yeah.
Okay, that's good to know. And something else that rang out to me earlier is you said that President Trump, obviously he's a very savvy business person.
Yes.
He registered for the real estate services subclass in China. But
Right.
in China, they don't acknowledge common law rights, right? So that other company registered his name for toilets. So
Yes.
how would you advise Trump if he could do it over again? Like, how would he protect himself and his brand if he wanted to, register, in China? Like, which subclasses? How would you know? Because it seems like, like
It's possible.
toilets, right?
It's impossible. Like, if there's one slide there that I share, like just to show you how wide, like you have to say the infringers in China are very, very creative. Like BMW T-shirt, for example.
Right.
So because the presentation, we are focused on people sourcing manufacturing in China. So I'm just absolutely protecting the core. But it's very interesting you asked that question, because just 2 days ago, I was doing a seminar for attorneys in the US. We are talking about big brands like Johnson and Johnson or BMW or Apple, for example. For big brands, if you have already reached a certain level of fame in China, we don't just file one class. You file 7 to 10 classes. You design, like for example, for hotel. If the hotel brand is really famous, you don't just file for hotel for class 43. You file hotel, absolutely. You file alcohol, high-end furniture, real estate, or real estate management services, travel. All of them are related. And you need to make sure when you go into China, make sure all are protected at the same time.
I see. And when you file 7 to 10 classes, is it like 10 times the costs, or is it just filing once so you can, add as many subclasses as you want?
You probably don't know, but you asked a very interesting legal question. It's what's called like is that a single class you count as 7 application,
Yeah.
or you count it as one application with 7 different classes? Does that
Right.
make sense? Okay. So what happens is that China does allow both, but because the system is so new, we need to file it 7 times. But there's a discount, always a discount for
Okay.
that.
I see. Okay. And let's switch gears a little bit. We had some student questions and some reader questions that I was hoping we can get to as well. In terms of like US, like switching gears to the US, when you're a new brand and you're doing research on trademarks, what is the right way to approach a trademark for your brand from the start? For example, what should you be looking for when you're coming in with your own brand name, and what's sort of the process to search for the clear with your own brand?
It's again, it's a huge question, so I'll just answer a little bit, like top 3, probably top 2 or top 3 key points. It really always the question coming back to ask the business is, what do you want to do in China? If your goal is really just to manufacture and source in China right now, by all means protect your absolute key right now. That's the first one. Second one is, I will ask, do you already have U.S. rights in China? Already have trademark rights in the U.S.? Because there's a treaty, like you can, like for example, I have a trademark registration in China. In the U.S. Within 6 months, I don't have to start from scratch. I can just extend that to China. Same thing, like for example, there's one of the startup that I was just talking to yesterday. Their key question will be like, what are the country I absolutely need to have protection in Asia? I'll be like, okay, where are you manufacturing? I'm manufacturing in China, Indonesia, Philippines. All 3 countries recognize first to file. So when you file in the US, what we do is within the first 6 months, extend to all 3 countries. And then you're protected that way.
I see. So if you already have a US trademark, you can extend that to
Yeah.
China. Is that right?
Yeah, there's a deadline, but most of the time we'll extend that to make sure absolutely the core you're protected. And if you want to become really technical, sometimes like the competitor already got your mark,
Right.
and you'd be like it's life or death situation. So there are really interesting strategies like you file in the US or you file priority in Iceland. You want to keep your brand hidden, but like 6 months later, when they become published, you already have rights in China. We're talking about really hidden strategy. So it depends on, are you pretty messed up already in China, or are you really new in China? Is there still room for protection? But I would say it really is important, like the Indiegogo example I shared at the very beginning. If you just file at the beginning, $2,000 take care of the problem. Right now, 10 years later, $200,000 still cannot address the problem because the manufacturing plant is already shut down. The outbound shipment is already ceased. We have to go through all the ports to unlock that one by one. It's very difficult, very costly, and it's just really unnecessary.
Right. Okay. Um, in terms of that 6 months, is that 6 months from the date that you file in the US that you
Right.
have to? Oh, okay. So it only okay. So it only applies to new trademark applications. You have that window. I see.
Yeah.
Okay.
Same thing with design pattern. A lot of the products, lifestyle brands like speakers, headphones, fitness equipment, watches, for example, a lot of them have unique features. So what we do, design patterns, the same thing. They have 6 months period.
Mhm.
So file that in the US, extend that to China.
Mm, that's a
Yeah.
great tip. Great tip. Okay.
Yeah.
And for stuff like this, would we need to hire a lawyer or can we do it ourselves?
The right answer from my part, I'll have to say you need to hire a lawyer.
Uh-huh.
It's really not just for me. Like for example, the slides that we shared at the beginning, the trademark we are dealing with in China right now, it's 10 times. In fact, it's 11 times the volume in the US. What that means is that in the US, even if you're a layperson, you're dealing with that yourself, you probably will be able to do that because there are not a lot of refusals. But in China, you're bound to have refusals. You are going to have a lot of refusals. So yes, of course, you can file it yourself, you can handle it yourself, but you will be rejected. By the time you get rejected, your rights, remember your priority is lost because you just abandoned that mark. You don't know how to respond to that. So it's time and money both lost. So I would just say, go ahead and have somebody who's experienced, know how to predict. Because right now we can even predict like, okay, Gary, you're gonna file a mark. It's on the sports brand and class 2804, that is your absolutely key class, key subclass. But there are two people ahead of you. What should we do right now? There are ways that we can figure out right now before you file and say, Gary, you're going to have a lot of problems. We need to take care of these two first before we can file. So your money will not end up getting lost and you still protect your seniority.
Right. Yeah, that makes a lot of sense. Yeah. In terms of the priority lost and the time lost.
Yeah.
Okay. All right. So yeah, this is great. We covered a lot today, and with with our course and with our site, we always try to apply the 80-20 rule or the 80-20 principle, right? So if there were just one thing that our viewers can take away and to act on right now, what would that be in your opinion, Amy?
I think the most important thing for me is be proactive in China.
Mhm.
Be absolutely proactive. When you go in there, business is great, market is great, but be proactive on the legal side because if you don't protect that right now, things are bound to happen and it's going to become more costly. So just be proactive. You don't want to be reactive.
Right, right.
Mhm.
Be proactive, don't be reactive.
Yes.
Excellent. Okay, thank you so much, Amy. This is great. I learned a lot today. I'm sure our viewers will also. And if they wanted to follow up with you, how can they do that?
I do have the email. I put my email in the slides, and
Mm,
also they can follow up on. They can reach out to me on LinkedIn. I even put my WeChat there. So, or you can just Google Amy Xiao. I have a lot of publications there, so it will all link back to me.
perfect. And you also
Mhm.
have your blog as well, right? About China trademarks. Yeah.
Yes, last week in
Excellent.
China. So
Yeah.
easier. What happened last week? We put it out there. So
Yeah. Last week in China. I love it. The most cutting edge news. Perfect.
thank.
All
Mhm.
right. Thank you again, Amy. This has really been great. I really appreciate your time. And we'll keep in touch and wish you all the best. We'll talk soon. Okay.
Thank you, Gary. Thank you
Thank
all.
you.
Bye.
Bye.